Thank you so much for having me, and thank you for that introduction. I am very happy to be standing here tonight next to my client, Kendra Espinoza, who I also consider my friend. Kendra and I met 4 years ago in a coffee shop in Montana. And it was then that Kendra agreed courageously to be the lead plaintiff in this case. She had no idea that she was about to become the face of the biggest education case in 20 years. I had an idea. Don't tell her that. Let me give you a little background. So this all started in 2015 when the Montana legislature decided to enact a school choice program. They were following the lead of 28 other states and the District of Columbia, all who had a lot of success with these programs. But unfortunately, in Montana, politics got in the way. The agency that was in charge of the program was the Montana Department of Revenue, and they decided to pass a rule that would limit scholarships just to children going to non-religious schools. So we sued. We joined up with Kendra and 2 other moms who wanted to send their kids to Stillwater Christian, and we said this rule violated the free exercise clause because it was singling out religion for unequal treatment. The government's supposed to be neutral, not hostile toward religion. We won at the trial court, but then at the Montana Supreme Court ruled against us. And when they did that, they had 2 holdings. First, they said that in Montana, no student aid program could ever include religious options, including this program. And then they did something surprising. They struck down the entire program, not just for the kids at religious schools, but for all the children. And the reasoning of the court was that that was the only way to ensure that not one dime went to a kid at a religious school. So why did the court do this? Why did the court conclude that giving scholarships to kids was unconstitutional? Some of you may know that in 2002, the US Supreme Court had already ruled that school choice programs were perfectly constitutional under the Establishment Clause. That was the Zellman versus Simmons case in 2002. So why did the Montana Supreme Court come out the other way? Anyone want to take a guess? Blaine amendments, that's right. Who here has a good idea of what a Blaine amendment is? Raise your hand. Okay, a fair amount of you. I'm going to give a refresher. So this is just a 2-line refresher. I'm not going to go into the whole thing. So Blaine amendments were our state constitutional provisions that were largely enacted in the 1800s. And on their face, they seem to be setting up stricter barriers between church and state, stricter barriers than exist in the Establishment Clause. But in reality, they were enacted to discriminate against Catholics and Catholic schooling at a time when this country, including Montana, was predominantly Protestant. Now, today, these Blaine amendments are the biggest legal barrier to school choice programs. A victory in this case would remove Blaine amendments as that barrier. And it would allow hundreds of thousands, maybe even millions of kids to participate in school choice programs for the first time. Now, I have more good news for you. We're going to win this case. This case is often talked about in terms of religious liberty. But it's so much more than that. At its core, this case is about parents' right to choose. Parents' right to choose a school that best meets their child's individual needs, whether that's going to be met at a secular school or a religious school. The public schools work fine for most kids, but education is not one size fits all. A lot of kids are floundering in the public schools or just not meeting their potential. Maybe that's because they're getting bullied and they don't feel safe going to school. Maybe it's because they have special needs, whether they're disabled or gifted. Or maybe it's just because they need a school that's teaching them the same values that they're learning at home. Parents should have a choice where their children go to school, and they should have that choice regardless of how much money they make. That's what school choice is about, and that's what this case is about. And we're going to win it. Thank you.